Does a living will need to be notarized? Have you ever wondered if a living will needs to be notarized? This is an important question in the realm of estate planning and advance healthcare directives. A living will, also known as an advance healthcare directive, is a legal document that outlines your wishes for medical treatment if you cannot communicate those decisions. The rules about notarization can vary depending on where you live. In many places, including California, a living will must be signed in front of either two adult witnesses or a notary public. This means you have a choice. You can either have your living will witnessed by two impartial adults or have it notarized. The main goal of this requirement is to confirm that the document is authentic and that you signed it voluntarily and competently. When a notary public is involved, they officially acknowledge your identity and witness the signing process. If you choose to have witnesses, they must be two adults who are not related to you and who are not involved in your healthcare decisions. This helps ensure that the document is valid and reflects your true wishes. It is also important to note that a living will is different from other estate planning documents, like a last will and testament. While you can have a living will notarized, it is not always necessary. For a last will and testament, notarization alone does not make it valid. It usually requires two independent witnesses as well. From the perspective of elder law and estate planning, making sure your living will is properly executed is very important. This helps prevent any challenges to the document's validity. It also ensures that healthcare providers and your loved ones can rely on your expressed wishes. To make sure your living will is valid, you should sign it in front of a notary or to witnesses who are not beneficiaries or involved in your care. Keeping copies of the document accessible is also a good idea. Make sure to inform relevant parties, such as healthcare providers and family members, about where the document is located. In summary, a living will does not always need to be notarized. However, it must be either notarized or witnessed by two eligible adults to be legally effective. This requirement helps safeguard the document's authenticity and supports the enforcement of your healthcare preferences.